Is there any part of your argument section, Mr. Ramsaran, that you can point to and say this made an argument?
No.
We are here today on an order to show cause as to why sanctions, including attorney's fees and costs incurred by the appellee, should not be imposed against counsel Jerome Ramsaran personally, pursuant to both Florida Rule of Appellate Procedure 9.410A, as well as Section 57105 1B of the Florida statutes. All right, so sir, what I'd like to start with is, could you please tell us how long you have been practicing law?
This month makes my 10th year in practice.
Okay. And how many appeals throughout that practice have you handled?
Maybe more than 10, less than 20?
More than 10 appeals.
More than 10.
And for how long? How many years have you been practicing appellate law?
I've probably been engaged in the appellate circuit. I mean, as far as filing appeals, I don't want to say anything incorrect, but I believe at least for the last 5 years, if not more.
But you're primary on your appellate cases, is that correct?
Correct.
Okay. And sir, have you reviewed all of the Florida rules of appellate procedure?
I'm fairly familiar with them. I won't say I know them all inside and out, but I mean, I know how to, use my resources as needed and to try to comply with the rules as necessary.
When I look to the argument portion of your initial brief, what I find are a plethora of citations to sort of, I want to say boilerplate or well-settled rules of law that I don't believe either party contends aren't applicable here. But there's just a sort of broad rule. There's no argument with regard to any of those citations. And so can you tell me about that and why there is no analysis in the argument section of the brief? And I'll tell you why I'm asking you that is because under Rule 9.210B5 of the Florida Rules of Appellate Procedure, that rule requires an argument with regard to each issue that you intend to raise on appeal.
If I may I pull up the initial brief?
Yes.
I wasn't aware we'd be talking about it today. Give me a moment. Let me grab that.
What's unfolding here is a textbook appellate procedure issue that quickly escalates into a credibility problem for counsel. The judge isn't just nitpicking formatting, he's pointing directly to Florida Appellate Rule 9.210B. 5, which requires a clear, structured legal argument for every issue raised on appeal. Without that, a brief isn't just weak, it may be considered procedurally defective. And notice the tension building. The judge is separating two entirely different questions: whether the underlying case had merit and whether the attorney properly presented that case under appellate standards. That distinction is critical in appellate law because even a potentially valid claim can be rejected if it's not properly argued. So here's the real question for the audience. If an attorney files an appeal with citations but no actual legal reasoning connecting those citations to the facts, should that be treated as a harmless mistake or a serious professional failure that risks sanctions? And as the judge starts signaling no serious attempt to meet the burden, you can feel this shifting towards something much more severe than just a bad filing.
Counsel, I'm a little surprised that you say you didn't understand we'd be discussing your brief today when the order to show cause specifically said the hearing was about your brief.
Respectfully, Your Honor, I thought the hearing was with regard to the fact that I did not provide a response to the June 18th show cause order.
The order to show cause says why sanctions should not be imposed against him pursuant to Florida Rule of Appellate Procedure 9.41A for, quote, filing a brief that was frivolous or in bad faith. Counsel, you seem there's two different issues here, and I think we're trying to get you to address one and you're addressing the other. So there's the merits of your claim and whether or not you all had an argument you could have made that wasn't frivolous. Okay. Then separate from the merits, there's you complying with your obligations as appellant's counsel to put those arguments into a brief. So before we get to the kind of merits of whether or not you could have had a claim, right, and whether or not the trial court did in fact err, you had some basis to dispute that, I think the issue is you wholly failed to articulate an argument in your brief, even assuming you had one. There's just no argument at all. The argument section that you have labeled argument is just kind of a cut and paste from various rules and cases with no explanation whatsoever how any of those authorities, make an argument, why the trial court would have erred according to those authorities. There was just no serious attempt to meet your appellate burden. So it's not really the merits of your claim we're at this point, although I looked at them and it does seem the claims were frivolous. At least it's hard to completely evaluate what argument. Just looking at the record, it's very hard to see how you could have made a meritorious argument. But we're not even there yet because we're just talking about the contents of your brief and the complete failure to include an argument section and to comply with Rule 9.210, requiring you to set forth arguments on each point of appeal. You had 2 points of appeal. There was no argument section. There was nothing in your argument section to support or put forth an argument on those 2 points of appeal. Do you see the distinction I'm making?
I do, Your Honor. I see it's more, substantive as to what's in the brief itself.
Is there any part of your argument section, Mr. Armstrong, that you can point to and say this made an argument?
No. The argument section recites certain case law.
Is it your understanding of the Florida Rules of Appellate Procedure that you are permitted to make argument in the factual background section of your initial brief?
No, Your Honor, but I didn't think it would be inappropriate to do so. I mean, this was not...
To put argument in the facts section?
We did put the arguments there. As we set forth the facts, we stated our position on those facts, and I believe that what follows supports those positions.
Counsel, do you agree that the trial court's order comes to us with a presumption of correctness?
Yes, Your Honor. I never thought about it, but yes.
Explain to me how that, all of that taken together, would be a good faith appeal.
Judge Falcone wrote, for the reasons stated on the record, LSQ's motion to dismiss is granted. Foreman's second amended complaint is dismissed as to LSQ with prejudice. For the reasons stated on the record, Foreman's motion for leave to amend is denied as amendment would be futile.
But Your Honor, in this case, there was no transcript or anything of that nature in this case. We have no record of what was stated at that hearing.
Counsel, it's your burden to demonstrate that the trial court erred in dismissing the complaint. Is that correct?
Yes.
Wouldn't that have been something important to determine before you filed an appeal? Because there's a lot of things in here that are like, even in the statement of facts, either obvious misstatements or otherwise mistaken. You tell us there's a U.S. District Court for the Western District of Florida. That obviously doesn't exist. You make a lot of statements about like at all material times there too, but then you make a statement that kind of by its nature cannot be done at all material times there too, like something that happened on a specific date. Like you said, like at all material times there too, the parties entered into a contract, or at all material times there too, a particular pleading was filed. Things that by their nature don't happen at all material times there too, that happen at a specific point. So that kind of made it hard for us to even follow the statement of facts because it just large parts of it were nonsensical.
I see. The reason we put that statement in at all material times, we're trying to point the court to the pertinent facts that upon which we're basing our arguments. For example, where we say at all times material here too, Foreman submitted the 5th invoice to Halloran for materials and labor.
Well, that's what I'm saying. Can you submit an invoice at all material times throughout a dispute, or do you submit an invoice at a particular time?
Well, at a particular time, but in reference to this action, what we're trying to say here, that we're trying to say that this is a pertinent fact, and maybe there's a better way I should have said that, but that's what we're trying to say by way of that introductory remark.
Counsel, if we were to conclude that this brief was frivolous or in bad faith, what do you believe the appropriate sanction would be?
I mean, I would ask this court not to monetarily penalize us. I don't know what other sanctions or options are available. This is the first time I find myself in a situation like this.
Counsel, after hearing from us, do you think the brief had any merit? Not your claims, but the brief.
I believe the brief has merit, but I think it could have been written much better. And albeit I didn't write this necessarily, with that said,
Who did write it?
my assistant. He prepared it. I looked it over. I granted it didn't follow the standards of our argument standards, but I thought it made sense.
Is your assistant a lawyer?
He was a lawyer at one point in time.
Okay. Well, is he a disbarred lawyer?
Counsel, I hear you say that you thought that the brief made sense. Did it, I guess at that time, were you aware that it did not comply with the Florida Rules of Appellate Procedure, either with regard to the appendix, the record, the factual background statement, or the argument section?
With regard to those procedural components, probably not. In all candidness, probably not.
But counsel, if I could ask you, sort of circling back, do you understand that we could find, just for the sake of argument, we could find that maybe you made a non-frivolous argument before the trial court, but that brings us back here with the rules and the requirements of an actual argument in the brief, the requirement that prohibits you from providing us with documents outside the record, and your failure to provide a transcript, which would perhaps show us, or you're aware that the rule also allows you, in the absence of an actual transcript, to work with appellee's counsel to reconstruct the record before the trial court. Are you aware of that under the appellate rules?
No, I am now. Thank you, Your Honor.
Okay. Which cases do you believe would support your request that we not sanction you for a frivolous appeal?
Understood. I don't believe I cited to anything of that nature, Your Honor, in my response.
Would you like to make any sort of argument or response as to why we shouldn't sanction you for a frivolous appeal?
Yes, Your Honor. I mean, I would argue that, at least as far as the amended brief, and granted, you know, I've been fully briefed on the deficiencies and the problems with that document as of now, but I would argue that, although out of place, the conclusions, the arguments, the support, legal precedent, I believe all the components are there to make those proper arguments. And then what follows from there is support that's intended to support our position or argument. And I agree that it's not necessarily the way I would have drafted it or preferred it to be drafted, but at the time I looked at it, the time I read it, I did not acknowledge or appreciate, well, I guess, that this type of issue could ensue, or that it could be construed as frivolous.
Mr. Ramsaran, anything further, sir, before we adjourn today?
Nothing that comes to mind, Your Honor.
Okay. All right. All right. Thank you for your presentation. We will issue an order on today's hearing. As of now, we're adjourned.
At the end of this hearing, the court is left weighing not only the strength of the underlying appeal, but whether the appellate brief itself failed to meet basic procedural requirements. The judge highlights a consistent issue, legal citations without analysis, factual inconsistencies, and a lack of structured argument tied to the actual grounds of appeal. What makes this significant is the potential consequence: sanctions for a frivolous or bad faith filing. failing. That's a serious finding in appellate practice, and it directly affects both credibility and financial liability for counsel involved. The court is essentially determining whether this was a flawed legal effort or a procedural breakdown severe enough to warrant punishment. If you break it down, this case becomes less about the original dispute and more about professional responsibility inside appellate courts, where precision, structure, and compliance with rules aren't optional, they're mandatory. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.